Well, good evening, everyone, and happy Wednesday to all of you. So, surprise, didn't think I'd be live streaming tonight, but a couple things hit the news that I thought I needed to talk about before the information got stale and before essentially the media went wilder than they had been. So, for any of you who don't know who I am, my name is Rob. This is the channel Law and Lumber. I'm a lawyer, trial attorney in Northern Virginia, and I've been practicing for more than 10 years. And I also am just a complete golf addict. So, yeah, I keep track of a lot of things going on with golf, and I listen to a bunch of podcasts. So, when this news hit the news cycle, I was really kind of irritated by how incorrect a lot of the information was. So, what are we talking about? Why are we here right now? And what's going on? Let's go ahead and get straight on into it, okay? All right. So TMZ ran an article this morning, kind of hit the right out of the gate. And the headline of the article kind of begins our discussion on some of this being misleading. So from TMZ, Tiger Woods' ex-girlfriend says the NDA is unenforceable, cites law regarding sexual assault and harassment. Well, right there, you have a little bit of innuendo as to how they are viewing this narrative. There is Tiger Woods and his now ex-girlfriend, Erica Herman. So to the article itself, Tiger Woods' latest girlfriend of about 6 years is taking the golf legend to court over an NDA, non-disclosure agreement, she claims he made her sign. And she's citing a law that prohibits NDAs when there's evidence of sexual assault or harassment. Erica Herman filed legal documents obtained by TMZ, which spell her grievances out clear as day. Namely, she alleges Tiger Woods made her sign an NDA at the start of their relationship around August of 2017, according to her, which she now says is being wrongfully enforced on her. In the paperwork, Herman says a private trust that Tiger runs is attempting to steamroll her into keeping quiet about their relationship by aggressively enforcing the NDA she signed. She argues in her legal documents that NDA should be declared unenforceable under the Federal Speak Out Act, which prohibits the enforceability of an NDA agreed to before a dispute arises involving sexual assault or sexual harassment. By the sounds of it, she and Tiger are no longer together, but she doesn't specify when they broke up. Publicly, there's been no sign of a split. We're going to find out that's not really true. Although we haven't quite seen Herman and Tiger together for a while now, even at his latest golf outing a few weeks ago. In any case, Herman says she's seeking to clarify from the court here because, according to her, she's eager to share her experiences with Tiger. Wants that tell-all book. She wants a judge to declare the NDA invalid and unenforceable. We've reached out to Tiger's team. So far, no word back. Well, that last bit is not surprising at all. Look, I've seen how these different celebrities have their PR teams and legal teams, and they're good. They're really good at covering information and making sure this stuff doesn't get disclosed or leaked too early. However, I've never seen anything like Tiger Woods' legal team or his PR team. This is a man who had a catastrophic injury after an accident with a vehicle he was operating. And the only thing that we got from the entire scene was essentially the sheriff acknowledging the accident occurred. No reports, no nothing. That thing was locked down like you could not believe. So his camp has been remarkably hush-hush. He's a master at this. That said, what about this is a little bit misleading? Well, let's go to some of the other articles from today. New York Post runs the article again. Tiger Woods' ex, Erica Herman, wants NDA nullified over sexual harassment clause. Okay. Ex-girlfriend filed lawsuit against the golf legend, asking to be removed from her non-disclosure agreement, citing a law that allows such NDAs to be voided if there is proof of sexual assault or harassment. Well, that becomes even more misleading because that's now suggesting that she has that proof. Herman, 38, is seeking to legally nullify the NDA she made to sign in August of 2017 when she first started dating the 47-year-old golf star, according to court papers obtained by the Post on Wednesday. She claims the NDA shouldn't be enforced in part because of the Speak Out Act, which was put in place to protect sexual assault and harassment victims. There are no specific allegations of assault or harassment referenced in the court documents. Representatives for Woods and Herman did not immediately respond to the Post's request for comment. Herman, a former restaurant manager, claims Woods is trying to enforce the NDA via his trust amid so-called litigation. It wasn't immediately clear what legal action the filing is referring to and whether it's ongoing. That's interesting. According to the complaint, Herman is also seeking clarification from the court on what she is legally allowed to disclose publicly about her near 6-year relationship with the golfing champ. So let's see. That then allows us to kind of see that we have at least one lawsuit. So let's go ahead and take a look at that. Let's pull the original lawsuit that she filed. There we go. All right. So here's the filing that was being referred to by all of these different articles. In the circuit court for the 19th Judicial Circuit in Martin County, Florida. Erica Herman, plaintiff, versus Eldrick Woods, Tiger Woods. Complaint for declaratory judgment. The plaintiff, Erica Herman, by and through undersigned counsel, hereby files her complaint against defendant Eldrick Woods and states as follows. Jurisdiction, venue, and parties. Basic stuff. The court has jurisdiction because it's an action for declaratory judgment. It involves a dispute in excess of $50,000. Plaintiff is an individual whose residence is 462 Beach Road, Hobe Sound, Florida. Now you'll see why she makes this argument here in a second, because this is Tiger Woods' residence. Defendant resides at 462 South Beach Road, Hobe Sound, Florida. Again, we'll get into why these are being alleged to be the residents of the parties. And by the way, the name and the address of Tiger Woods' estate is not a public secret. That has been well known for quite some time. So I'm not really concerned about that being in the pleadings. General allegations. The case involves a purported non-disclosure and acknowledgement agreement dated August 9th, 2017. The plaintiff had a long relationship with the defendant, both professionally and personally. During the course of the plaintiff's employment for him, the defendant caused Woods' NDA to be executed. A trust controlled by the defendant has taken the position in litigation, that's referred to in the lawsuit or in the article we saw by the New York Post, that the Woods NDA is enforceable against the plaintiff. The trust also disclosed in litigation the defendant has asserted that the Woods NDA is enforceable against the plaintiff by commencing an arbitration against the plaintiff based on it. Well, now you can see why New York Post was confused, because it references other litigation. It wouldn't have been that hard to find if they had just done some searching. The plaintiff believes that the Woods NDA is invalid and unenforceable. However, these issues are not legally certain, and the plaintiff is in current doubt about her and the defendant's respective obligation and rights, if any, under the Woods non-disclosure agreement. The uncertainty is acute and important. Because of the aggressive use of the Woods NDA against her by the defendant and the trust under his control, the plaintiff is unsure whether she may disclose, among other things, facts giving rise to various legal claims she believes she has. She's also currently unsure what other information about her own life she may discuss or with whom. There is therefore an active dispute between the plaintiff and the defendant, for which the plaintiff needs a clarifying declaration from the court. So there we go. So that's essentially the basic allegation. There's no allegation of specific sexual assault or harassment in this case. What she is asking the court is that she might have facts giving rise to various legal claims she believes that she has. What those claims are, we don't know. So why the reference to the sexual assault and harassment? So this is again seeking declaratory relief. What they're asking for the court to do in this circumstance is asking the court to essentially review the document, make a determination onto its validity, and say whether the document is or is not valid. Going through blah, 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 we get to the meat of the issue. All right, here we go. The plaintiff's request for declaratory relief addresses a present ascertainable controversy about the existence or non-existence of an immunity, power, privilege, or right under the Woods non-disclosure agreement. The requested declaration would also address at least one fact upon which the existence or non-existence of such immunity, power, privilege, or right does or may depend. Whether such immunity, power, privilege, or right now exists or will arise in the future, included but not limited to the circumstances of the execution of the Woods NDA. She basically wants the court to determine whether she does or does not have rights and what she can or cannot say with the existent NDA. This document here, or this statement here, but not limited to the circumstances of execution, means that she might try to get this thing deemed invalid based on the circumstances, mentally, leverage, power, compulsion surrounding the signing of that document. Only the defendant and the plaintiff are purported parties to the Woods NDA, and therefore all antagonistic or adverse interests in the Woods NDA would be before the court following proper process. The relief sought is not merely of giving legal advice by the courts or the answer to questions propounded from curiosity. That's essentially to get over the hurdle. Courts are not allowed to give advisory opinions, which means they can't just make it an interpretation of law without an actual controversy that needs to be resolved. So she has to plead that particular issue. The plaintiff requests the court grant her a declaration that the Woods NDA is not valid or enforceable, including but not limited to because of lack of consideration and because of unconscionability. This thing is so grossly unfair that it cannot be enforceable. That's what that basically translates to. In the alternative, if the Woods NDA is valid and enforceable in any part, defining the specific scope of any obligations on the plaintiff under the Woods NDA. So please, if this thing is valid, let me know what I can do. Including but not limited to whether and to what extent it limits the plaintiff from plaintiff's freedom to disclose, 1, her own personal experiences, 2, the experiences of her family members, 3, photographs and recordings of herself and her family members, 4, information held, witnessed, or learned by people who are not covered by the Woods non-disclosure agreement, 5, information from sources other than the defendant, 6, information on topics that the defendant has discussed or otherwise disclosed to other people who are not covered by the Woods non-disclosure agreement, 7, information required to be permitted to be disclosed by law, regulation, and or rules, and or 8, information responding to statements that the defendant has made or published about her or others to prove the falsity and misleading nature of those statements. Okay, now we're starting to get into it. Now we're starting to understand a little bit more about this document. So she wants to get out ahead of Tiger Woods making any statements about the end of their relationship. We don't know anything about what she's going to say at this point in time. Like I said, NDA is in place. So then see that the purported arbitration clause in the Woods NDA, she really doesn't like the arbitration clause, and we'll talk about why, is unenforceable as to the plaintiff's claim in this case, and that any determination of its applicability in the case must be decided by the court, not by an arbitrator, under the Federal Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021, Chapter 9, USC, Sections 401 and 402. And then D, that the Woods NDA is not judicially enforceable in this case under Federal Speak Out Act, Title 42, USC, Sections 19401 through 404. Therefore, please give me judgment against the defendant, granting my requested relief and my attorney's fees and costs and other relief as the court might deem proper. Plaintiff demands trial by jury. They have to make that demand. So there's the pleading itself. So why did the initial reporting on this fail to disclose that other litigation? Or when making reference to the other litigation, why didn't they look it up? Let's talk about that. So this is the other litigation. All it would have taken was a simple docket search to go back through the docket and basically search not by Mr. Woods' name, but perhaps by the plaintiff's name, Ms. Herman. And now we've got some context, and we're going to keep getting context as this moves forward. So Erica Herman versus the Jupiter Island Irrevocable Homestead Trust. A lot of you guys are going to be very confused about that. This trust, you're going to see in a minute, was created to hold the property that serves as the residence for Tiger Woods. Okay. So the complaint for violation of the Florida Landlord-Tenant Act. The plaintiff, Erica Herman, by and through her undersigned counsel, hereby files her complaint against the defendant, Jupiter Island Irrevocable Homestead Trust, and states as follows. So it's a lawsuit against the trust. This is an action for damages in excess of $50,000. Plaintiff is an individual who resides at 462 South Beach Road, Hobie. I don't know how it's pronounced. Hobe Sound, Florida. I'm going to say Hobie. It sounds better. Defendant is an irrevocable trust with its place of administration in Hobie Sound, Florida, and the owner residing at 462 South Beach Road, Hobie Sound, Florida. All conditions precedent to this lawsuit have been satisfied or waived. So basically, I've satisfied all the things I need to get into court. That's what the allegation is. 5, by agreement with an agent with actual or apparent authority to act for the defendant, the trust. Plaintiff, Erica, has resided at the residence for the duration of the defendant's ownership for as long as the trust has existed. During that period of time, plaintiff has performed valuable services at the request of defendant's agents, all in part performance of the oral tenancy agreement and in reliance thereon. So here's what she's saying. She's saying that a promise was made between the trust and her that she would be permitted to reside as a tenant on this property that is also occupied by Tiger Woods. The oral tenancy agreement gave the plaintiff, Ms. Herman, the right to live in the residence for a certain duration of time. All expenses that related to the plaintiff's residence, Mr. Woods' residence, or that resulted therefrom were to be fully paid by the defendant or its privies. So essentially, all the expenses related to Ms. Herman's residence, her living in that place, the power, the electricity, all of it, was to be paid by Mr. Woods. This agreement was fully performed for a 6-year period prior to the events giving rise to this lawsuit. The duties that were performed by and expected of Ms. Herman were extensive and of an extraordinary nature in light of the overall circumstances and environment in which she lived. She did a lot to maintain the benefit of living in that home. That's what she's saying. Approximately 5 years remained on the oral tenancy agreement. So she is saying, not only have I resided there for 6 years, but there was a guarantee that I would be permitted to reside there for another 5. So an 11-year agreement that was made verbally with a trust through an agent of the trust. That's what she's saying. The trust was going to provide for all expenses for her living in the property, and that was supposed to exist for a full 11-year period. Now, I'm not a Florida attorney. I am a Virginia attorney. What I will tell you is that when you have no written instrument, generally speaking, it's a presumed month-to-month or week-to-week tenancy depending on what rate the rent is collected in. Again, not a Florida attorney. Other issues here is that you have her suing. Why did my brain just give out for a second? What was I talking about? The trust tenancy agreement. Yes. Other issue that I'm kind of seeing with this is that generally speaking, landlord-tenant acts are limited in scope. They're usually limited to provide relief against large entities that own multiple units. A lot of states will have limitations. For example, in Virginia, I believe it's 50. You have to own and rent out 50 different properties in order to be subject to the act by default. It's not usually meant for these one-off circumstances where one person rents a property out to another person. So that's just saying. Number 7, no notice or lawful judicial proceeding was commenced to bring the tenancy to a lawful end. Instead, the defendant elected to engage in, quote, prohibited practices, end quote, i.e. self-help, which is you kicking somebody out, causing severe actual, consequential, and severe emotional damages to Ms. Herman. The prohibited practices were done intentionally with premeditation and with malice aforethought. Again, these are just allegations. That's what these are. Specifically, by trickery, agents of the defendant convinced the plaintiff to pack a suitcase for a short vacation. Reminder, plaintiff is Ms. Herman. The defendant is the trust. Agents of the trust could be Mr. Woods or anyone acting on his behalf. So they convinced Ms. Herman to pack a suitcase for a short vacation, and when she arrived at the airport, they told her she had been locked out of her residence in violation of the oral tenancy agreement and in violation of Florida law. Drive to the airport with a bag. By the way, we changed the locks. They then informed her she was not allowed to return to her residence, and without legal counsel to aid her in this emotional moment, they utilized a lawyer to confront her with proposals to resolve the wrongdoing they were in the midst of committing. Well, that's interesting because that sounds like a negotiation towards settlement, which I don't know that you can bring in evidentiarily speaking. But in any event, she's saying lawyer approached her after they dropped her off at the airport and said, BT dub, how could we resolve this amicably without anyone going to court? Okay. So the trust's agents attempted to justify their illegal conduct by paying for a hotel room and certain expenses for a short period of time, having successfully locked the plaintiff out of her home and frightening her away from returning. So she was afraid to go back. Essentially, she was locked out. They said, here's a hotel. We're going to put you up here. And I say they. I don't know if it was they, Tiger Woods, anybody. Right now, the only thing that we have as the defendant is the trust. So not a whole lot going on there. The defendant's agents attempted to justify their illegal conduct. Oh, I already said that part. Since then, plaintiff has continually demanded to be allowed back into her home, but defendant's agents have refused. Even worse, defendant's agents removed plaintiff's personal belongings from her residence and misappropriated in excess of $40,000 in cash that belonged to her, making scurrilous and defamatory allegations about how she obtained the money. Now, this was something that was kind of funny. This didn't get reported very anywhere. Honestly, I didn't see this lawsuit reported almost anywhere until late in the evening when people started correcting their stories. Thank you, MSVG3. Hobe sound, you got it. I'll correct that issue. So, removed her belongings, and they say, by the way, this $40,000 in cash, there were some scurrilous and defamatory allegations as to how she obtained the money. If you're a speculating person, again, just speculation, the argument could be, yeah, you stole it, you took it, it wasn't yours, etc. Right? So that would make sense as to why she's alleging that these statements being made were defamatory. So agents of the defendant conspired to engage in the above described statutorily prohibited and tortious practices in order to interfere with the plaintiff's advantageous contractual and business relationships. It's, having a house that all expenses are being paid is an advantageous contractual relationship for their own personal profits and through undue improper influence. Upon further discovery, such persons will be added as additional defendants, and if appropriate, amendment will be sought to allege punitive damages. So to the extent that we find out anything terrible, we are going to go ahead and add additional defendants that engage in all these behaviors. And now we get to the very interesting part. Plaintiff's actual and consequential damages in terms of the reasonable rental value of the residence will be determined at the time of trial, but is likely to be measured in excess of $30 million, given the substantial monthly rental value of the residence. So here's the argument that she's making. She is making that she was promised this particular rental, that renting and occupying this residence free or paid for by her other services, whatever they were, that residence was promised to her, and therefore, because she's excluded from that residence wrongfully, she has the right to seek money that would allow her to reside in a similar residence to that which she was occupying. For those of you who don't know what Tiger Woods' estate looks like, let's go ahead and pull up a picture. Jupiter Island estate, because this can be very, very interesting. Let's see if we've got something. There we go. We're going to go ahead and open that image in the new tab. And we'll do this momentarily. We'll pull down this screen and we'll go ahead and we will show you guys what this estate looks like. That's the home. That is Tiger Woods' estate on Jupiter Island. Among the things you're seeing there is a putting green, a lap lane, a pool with a different diving apparatus. I believe on one of the balconies, he actually has a little tee box set up where you can shoot out into the property. He's got a little 3-hole golf course there too, where you can practice. That's the property that she is saying she was excluded from. So she's basically saying, give me equivalent money to allow me to reside in a property of similar size, position, amenities, etc., free for the next 5 years. So, yeah, I've seen pictures of this estate so many times. It is just like beyond beautiful. My word. And I know people are going to have opinions on the look of it. I mean, I'm just look at all the amenities. I mean, it's a resort. It's a resort. And don't kid yourself. He probably has a staff that helps him manage that entire property. And I imagine not a small staff that's helping him manage that property. So $30 million of the damages that she's asking for, the defendant directly and through its agents had the duty and that was owed towards the plaintiff to not conduct prohibited practices pursuant to Section 83.67. The flagrant and purposeful violations and breaches of the duty described above are the proximate cause of the injuries for which plaintiff seeks monetary damages, which should be determined by a jury. Plaintiffs entitled to actual and consequential damages or 3 months rental value, whichever is greater, and or injunctive relief pursuant to 83.67 plus attorney's fees, costs, and demand for which is hereby made. So even with this one lawsuit, now you're getting additional context not originally reported in those articles. And the context here really, really matters because, again, going back to this original complaint that she's saying she wants this NDA set aside because, going back to the part here, there we go, right up here. So she wants that NDA set aside because the trust, controlled by the defendant, has taken the position in litigation that the Woods NDA is enforceable against the plaintiff. So that would be the other litigation that they just didn't happen to look up. The trust also disclosed in litigation the defendant has asserted that the Woods NDA is enforceable against the plaintiff by commencing an arbitration against the plaintiff based on it. So let's see what ends up happening. So this is the other part. This lawsuit here. So while the action that was reported on today as being breaking news was filed March 6th, this was filed October 26th of 2022. So sometime prior to this date is when this breakup occurs. Tiger Woods says, no, get out, and drives her to the airport, says, we're going to put you up in a hotel. We're going to pay some expenses, but at the end of the day, you got to leave. And then there's the dispute about the $40,000. All right. So let's go ahead and see what Mr. Woods does, rather what the trust does in the case. So on November 15th, the trust files this motion to dismiss. The motion to dismiss basically goes through and recites some of the allegations of the complaint. So this is an action for alleged violation of the Florida Residential Landlord-Tenant Act. Plaintiff alleges that she resided at 462 South Beach Road. I like this. This is lawyer shade. Because you'll recall I made the specific reference that plaintiff says that she does reside presently. And then within the first paragraph, the defendants are going, no, resided, like past tense. Yep. She alleges further that the residence is owned by the trust. Next, she alleges that she entered an oral tenancy agreement. I like that they throw that in quotes too, more shade, with an agent for the trust and performed unspecified valuable services, more shade, for the agent that were extensive and of extraordinary nature. Oh, I mean, you know what? The plaintiffs put that language in there. That's on them. I mean, infer what you will. That's lawyer shade. So, as consideration for these valuable services, the plaintiff alleges that the oral tenancy agreement gave her the right to live in the residence for a certain duration of time. According to the complaint, for the past 6 years, plaintiff performed services and lived in the residence pursuant to the agreement. She alleges that approximately 5 years remain on the oral tenancy agreement. Defendant allegedly breached the oral tenancy agreement because, without first commencing a lawful judicial proceeding to bring the tenancy to a lawful end, the trust's agent locked plaintiff out of the residence, removed her personal belongings, and informed her she could not return. Remarkably, Ms. Herman alleges that the value of her remaining 5-year tenancy is in excess of $30 million. That in exchange for plaintiff services, she was to be provided consideration in excess of $6 million per year. Essentially, if you're taking that $30 million, because they go to the footnote, love footnotes, footnote 1, in addition to the alleged right to receive the alleged rental value of the residence, plaintiff alleges that all expenses that related to the plaintiff's residency or that resulted therefrom were to be fully paid by the defendant or its privies. So that's the math. $6 million per year is what she is saying the benefit that she was giving was provided in exchange for. So the love, affection, traveling, all the other stuff, that was worth under this contractual relationship. And that's the other thing that kind of feels weird about this. She is suing the trust and saying that there was an agreement with the trust and she was going to provide services in exchange for this occupancy. This is her choice to bring that lawsuit. And it just feels weird. It just feels really odd. But Tiger Woods has deep pockets. Ultimately, plaintiff alleges that the actions of the defendant or its agents were prohibited practices under Florida Statute Section 83.67, entitling plaintiff to monetary damages, injunctive or declaratory relief, and attorney's fees. Lastly, though she fails to allege a single physical injury, plaintiff alleges that she is entitled to civil relief for personal injuries these breaches/violations have caused. Now, that single physical injury part, that's hinting at what she ultimately ends up doing with the motion or with the complaint to set aside the NDA. Then they give the standard review to survive the motion to dismiss. You basically have to allege a prima facie case. You have to plead specific facts that show the entitlement to the relief that you're seeking. You have to allege the sufficient ultimate facts to show that you're entitled to that relief. So then you've got these arguments on the motion to dismiss. These really aren't that relevant. We'll go through them pretty briefly. But like I said, these really aren't the relevant part. The relevant part is when we get to that motion to compel arbitration. That's what she referenced in her complaint to set aside the agreement. And that's what is kind of driving this new lawsuit. So they're seeking relief under the Florida statutes. Defendants or its agent allegedly violated Section 83.67 of the Act, entitled Prohibited Practices, which, among other things, expressly prohibits a landlord from preventing the tenant from gaining reasonable access to the dwelling unit or removing the tenant's personal property from the dwelling unit. Any violation entitles the tenant to damages and other relief provided by the Act. It creates a civil cause of action to enforce any right or duty declared in this Act, and it provides that if a rental agreement is not complied with, an aggrieved party may recover damages caused by non-compliance. Here you go. This is what I was referring to earlier. A tenant is defined under the Act as any person entitled to occupy a dwelling unit under a rental agreement. Critically, the rental agreement is defined under the Act as any written agreement, including amendments or addenda or oral agreement for a duration of less than 1 year. That seems to be pretty problematic for Ms. Herman. Providing for use and occupancy of the premises. Stated another way, to qualify as a tenant entitled to protection under the Act, the oral tenancy agreement must be for a duration of less than 1 year. Go through different citing case law. The court held that a landlord-tenant relationship is a condition precedent to applying the remedies. Makes sense. In Toledo, this case, the defendant and her boyfriend lived in a condominium owned by the boyfriend. After the relationship ended and the boyfriend moved out, the defendant continued living in the condominium for approximately 4 years. When the former boyfriend sold the condominium to a new owner, the new owner sued to evict the defendant under Florida Residential Landlord-Tenant Act, alleging the defendant was under an oral lease agreement with the former boyfriend. Relying on statutory definitions of tenant and rental agreement, the court determined that the alleged oral agreement between the defendant and the former boyfriend was not a rental agreement under Section 82.43 because it was not for a duration of less than 1 year. That seems to be a pretty similar case site, as evidenced by the fact that the defendant continued to live in the condominium for 4 years after the relationship ended. Further, because there was no rental agreement as defined by the Act, the defendant in Toledo could not meet the definition of tenant under the Act. So they said, no jurisdiction to apply the remedies. See you later. Get out of court. Similarly, I don't have to do the analysis. You guys essentially realize what we just walked through. The oral tenancy was for an agreement that was longer than 1 year in duration. Therefore, the Act does not apply. That's the argument being made here. The trust is not a real party in interest. A trust is not a legal entity. In its simplest form, a trust is created with one person, transfers property to a third party to administer the benefits of another. Now, this is a technicality. I think that you actually can end up suing the trust can't be sued, but I think you can sue the administrator of the trust. I don't know that that's the meat of their argument. I think the bigger argument is that whole 1 year issue here. Can't amend it to correct it. I think that's probably relatively well-founded. And that's essentially the basis of the argument being made in their motion to dismiss. That brings us to our last pleading. Defendant's motion to compel arbitration. And thus we have come full circle. Now we're back to the non-disclosure agreement that has been so widely reported in today's news. So defendant Christopher Herman, before I do this, let me make sure I've got everything I need in here starred. And then I'll get to questions at the end. Rosalind Duke, thank you very much. Started my own channel, dog videos, and my dog was hired by Chewy today. That's amazing. Need a bigger monitor, help with vision loss. Thanks for being so inspiring. Hoping to move into lifestyle videos. For now, it's silly dog videos. Rosalind, that's amazing. I'm very happy that you did that. I hope you really much enjoy it. It's a pleasure. It really is a lot of fun. Rua, the side. Don't let the facts get in the way of a good story. And the thing that I found most frustrating was every other article for at least the first half of the day referenced TMZ's legal analysis of the allegations within the complaint. They didn't even verify it until halfway through the day when they had their sources pull at least the original document, and then they didn't go any further than that. It was pretty shocking. Josh at 10 Hague, thank you very much for the super sticker. All right, catching up to where we are. So we've got the motion to compel arbitration and stay the eviction claims against the defendant. So the defendant, Mr. Hubman, who's the trustee, he's the lawful individual that is the trust. He's acting as the trust. He's the person that would or should have to be sued in this particular instance. As trustee, the Jupiter Island Irrevocable Homestead Trust moves for an order compelling arbitration of all claims in the plaintiff's complaint and to stay the claims against defendant during the pendency of arbitration. And in support thereof, he states, okay, in this action, plaintiff Erica Herman alleges that as consideration for certain services she performed in the last 6 years, the trust entered an oral tenancy agreement that gave her the right to live at 462 South Beach Road, Hobe Sound, Florida, for an additional 5 years. Ms. Herman alleges she negotiated an oral tenancy agreement with an agent of the trust. In reality, Ms. Herman was invited to live in the residence while she was in a relationship with her former boyfriend, Tiger Woods, who continues to live in the residence with his 2 children. After Mr. Woods recently terminated the relationship, Ms. Herman was advised that she was no longer welcome in the residence. So there's the breakup. Ms. Herman responded to the breakup by filing this lawsuit, which contends that the value of the alleged oral tenancy agreement is in excess of $30 million. Ms. Herman claims the alleged oral tenancy agreement was breached when, following the breakup, the trust's agents locked her out of the residence, removed her personal belongings, and informed her she could not return. Additionally, Ms. Herman claims in excess of $40,000 in cash belonging to her was misappropriated. As a result of the actions of the agents, Ms. Herman seeks actual and consequential monetary damages, injunctive relief, and attorney's fees and costs pursuant to the Florida Residential Landlord-Tenant Act. Ms. Herman positions her complaint as an action against the trust because she is required to arbitrate all disputes with Mr. Woods in a confidential arbitration before the American Arbitration Association. Ruh-roh. Specifically, at the outset of her relationship with Mr. Woods, Ms. Herman and Mr. Woods entered into a non-disclosure and acknowledgement agreement dated August 9th, 2017, a redacted copy of which is attached hereto as Exhibit A to reflect a true and correct copy of the agreement to arbitrate. Side note, I had questions here that were essentially asking me whether or not these agreements are valid non-disclosure agreements. Most states, I think almost every state, does view them as being valid. Rather, the better way of saying it's they're not presumptively invalid. They are enforceable provisions. It's essentially the same thing as having a confidentiality clause in a premarital agreement where certain matters as between the two of you are to remain confidential within the marriage. And when the two parties know what could or would arise during the course of that relationship or the contractual obligation, they are presumed to willingly and knowingly enter into this type of arrangement. They're not out of the realm of possibility. And honestly, a lot of celebrities have these, period. A lot of them do, because they don't want things that are discussed within the four corners of that household getting outside. If you think about it, think about banking transactions, think about their wealth, think about the conversations they have about third parties. Honestly, this is smart practice, especially for someone like Tiger Woods, who's had a lot of conflict and controversy in his life, in his personal life. So I made the comment about his legal team and PR team being remarkably talented. This is the indication that essentially they knew, in the extent something would come up, that they would want an agreement to fall back on to compel arbitration, get it out of the courts, get it into a discussion where we can resolve it without everyone seeing the inside of all of our lives, and without a salacious back and forth a la Johnny Depp trial. And you guys will remember from the Johnny Depp trial, these are presumptively valid. So here we go. Among other things, the agreement requires that any and all disputes, claims, or controversies of any kind or nature whatsoever between Ms. Herman and Mr. Woods are to be resolved by confidential binding arbitration before the American Arbitration Association. By suing the trust rather than Mr. Woods, Ms. Herman seeks to evade her obligation to adjudicate her claims in a confidential arbitration, and instead seeks to gain leverage by litigating her disputes with Mr. Woods in a public forum. Well, that just cuts right to the point of the issue. She has the NDA. Why wouldn't she go straight to Tiger and say, I have this agreement, we're going to arbitrate our dispute? She can compel it at any point in time. You kicked me out. That was unfair. We can arbitrate our dispute. And it goes to kind of some of the background that wasn't being reported on. And this is the frustrating part. Look, I don't pretend to know anything that was going on in this relationship. I don't pretend to know whether Tiger Woods was a bad guy that did terrible, terrible things, or whether Ms. Herman was a bad person that did terrible things. I don't pretend to know that. But when people are running news articles that are containing salacious headlines making reference to an NDA being thrown out because of allegations of sexual harassment, I take that pretty seriously. And I'm sorry, but the TMZification of mainstream media, where everything is trying to get clicks, this is remarkably prejudicial. The golf world just about blew up today. The number of tweets that I saw, the number of communications being exchanged, people bashing Tiger Woods, people coming to his aid, conflict that existed that wouldn't have had to exist if there was context provided to the damn article. Give people the background. And it didn't take you long. It took me 5 minutes searching her name in the court docket. It's publicly available, Martin County, Florida. It's all there. It would have taken no time at all for them to get this. And the pleadings themselves, you saw them. The complaint was, the first one was 4 pages. Motion dismissed, 9 pages. This one's 21, and a lot of it's exhibits. So, Sue, point taken. You need to refer to it as Jupiter Island. I think I'm going to do that from now on. It's just easier. Yeah. I don't mean to be bashing that. The pronunciation is terrible. It's on me entirely. But essentially, it's taking Tiger Woods, who is guaranteed to get clicks, and then it's making something even more glorified and just salacious than it really needs to be. When you see this from its original context, look, if this was about a sexual harassment or sexual allegation of sexual assault, those are exempt from NDAs, period. You can report those. Like, end of story. Report them. Please do. Absolutely do. If that stuff is happening. So it just starts, you just start to feel, you feel like weird, icky litigation, a little bit of it. Suing the trust and saying contractual relationship that was valued at $6 million a year. I mean, does it feel like ick to anyone else? No, just me. Oh, it's just weird. Anyways, moving on. Among other things, we already did that. No, we didn't. But yeah, by suing the trust, evade her obligation to adjudicate her claims in a confidential arbitration, instead seek to gain leverage by litigating her disputes with Mr. Woods in a public forum. So she wants the nasty knockdown, drag it out with Mr. Woods in a court. That's what she wants. The disputes raised by Ms. Herman in the lawsuit against the trust are quite plainly disputes between Ms. Herman and Mr. Woods. All disputes arise out of their breakup of their relationship, and all damages arise in connection with Mr. Woods' decision not to permit Ms. Herman to re-enter their personal residence following their breakup. Accordingly, the disputes raised by Ms. Herman in this action are subject to the broad arbitration provisions in the agreement, and Ms. Herman should be compelled to arbitrate her claims in a confidential proceeding before the AAA, as she and Mr. Woods previously agreed. Factual background. Here we go. The trust and the residence. On February 28, 2017, that's odd. Hang on. When did they start dating? When did they start dating? Why does this sound kind of odd to me? Or did Tiger raise that in his answer? When did they start dating? She doesn't put the date. Why do I feel like I've seen third-party reports saying they started dating in August? Well, let's see if the Google machine at least gives us a hint here. When did Tiger Woods and Erica Herman start dating? $2017. His first body of the President's Cup in 2017. But when? When was the President's Cup in 2017? September of 2017 is when they went public. So depending on the veracity of that could, I don't know that has any legal impact, but it's a curious point. So the trust was formed on February 28th. The same day, Mr. Woods deeded as grantor and transferred a remainder interest in the residence to the trustee of the trust while retaining a life estate in his individual name. A copy of the warranty deed is attached to Exhibit A. So here's the thing. Oh, yeah, she does. She says it. That's what it was. She signed. Yeah, thank you, Sam. Signed the NDA in August. Yeah, so at least one of her allegations is just not true. I don't know that has any bearing. It's just sloppy practice. So here, this requires a little bit of explanation. Well, we'll get through the next paragraph, then I'll explain it. The only asset ever held by the trust in its remainder ownership interest in the residence. The only potential beneficiaries of the trust are Mr. Woods' children and Mr. Woods. No one other than Mr. Woods' children or Mr. Woods himself has any right to the trust's remainder interest in the residence. Meantime, Mr. Woods continues to own a life estate in the residence and has the right to exclusive possession of the residence during his lifetime. So what this basically says is this divides the title to the property with the right to use and occupy. So a life estate is essentially for so long as the life of the person I'm giving this interest to, they're allowed exclusive use, occupancy, and enjoyment of the residence itself. Right. So that's a property interest that I'm transferring to them. They're entitled to have that. Once I give that to them, they own it. I cannot take it back. So that is what this is. So Tiger transfers keeps the life estate to himself. He says, I own the life estate for so long as I own this property, or for so long as I am alive, I am entitled to the beneficial use and enjoyment of the property. But then he transfers title to the property to the trust, which has named beneficiaries in the trust, namely the children. The reason why someone might do that is you break the chain, you break title from enjoyment and occupancy, because to the extent that someone sues Tiger Woods, he doesn't want people to invade all of his property and deplete all of that property that should be set aside, or he believes should be set aside for the benefit of his children. It's essentially an effective estate administration, estate planning tactic that gets these properties outside the reach of certain creditors to the extent that ends up coming up. It's a smart move for people that have certain valuable estates. Consult an attorney in your jurisdiction. Margaret Wang, thank you for being a member. So, going on, in 2017, after Mr. Woods and Ms. Herman commenced a relationship, Ms. Herman began living in the residence as Mr. Woods' invited guest. See, he's saying there was no agreement. Mr. Woods and Ms. Herman never married. Further, neither Mr. Woods nor the trustee of the trust ever transferred any ownership interest in the residence to Ms. Herman. No documents, no agreement with the trust, no instruments transferring assets, nothing there. Okay. Yes, tax advantage. Thank you, Kathleen. But I'm not a tax attorney. Oh my gosh, I'm not a tax attorney. Talk to a CPA, talk to a tax attorney, talk to those folks. I'm not giving advice on any tax advice. That stuff scares me. No one dabbles in tax law. So the plaintiff's claims. Now we're going to get Tiger Woods' narrative here. On October 13th, 2022, Mr. Woods notified Ms. Herman that he was breaking off their relationship. So the 13th, that was when he broke up. At that time, Ms. Herman was informed that she was no longer welcome in the residence. Ms. Herman then sued the trust, claiming for the first time that she and Mr. Woods, allegedly acting as the agent for the trust, entered an oral tenancy agreement relating to the residence. Well, interesting. That creates an even more complicated situation, because if this is an irrevocable trust, I don't know that he would have had the right to agree to that. Interesting. According to Ms. Herman, for the past 6 years, she performed services that, again, more shade, quote, were extensive and of extraordinary nature in light of the overall circumstances and environment in which she lived, end of quote. As consideration for her services, Ms. Herman allegedly lived in the residence pursuant to the oral tenancy agreement, which Ms. Herman alleges had approximately 5 years remaining at the time Mr. Woods broke off their relationship. Think of the nasty consequences there. Ms. Herman claims entitlement to injunctive and monetary relief against the trust because following the breakup, she allegedly was locked out of the residence, had her personal belongings removed, had $40,000 misappropriated, and was informed she could not return to the residence. And then to summarize, I love when attorneys do this. Thank you. Lest there be any doubt, Ms. Herman's claims against the trust are just thinly camouflaged claims against arising from disputes between Ms. Herman and Mr. Woods. A, Ms. Herman's claim arise from the breakup of her relationship with Mr. Woods. 1. B, Ms. Herman's claims arise from an alleged oral tenancy agreement reached with Mr. Woods. You can come live here. C, the subject of the alleged oral tenancy agreement is Mr. Woods' personal residence, which he shares with his 2 children. D, Ms. Herman's claim that she was wrongfully prevented from re-entering the residence involves conduct of Mr. Woods' agents acting pursuant to instructions from Mr. Woods. It's all him. E, Ms. Herman's claim regarding the misappropriated $40,000 involves the conduct of Mr. Woods' agents. What is with the $40,000? What is with the more? I don't understand. They don't make any more comment regarding that. F, by claiming the right to occupy the residence, Ms. Herman's claims are directly adverse to his personal interests of Mr. Woods and his 2 children, who are the current occupants of the residence. By claiming damages against the trust, Ms. Herman's claims are directly adverse to the personal interests of Mr. Woods and his children because they are the only beneficiaries of the trust and because the only asset of the trust is the residence which Mr. Woods shares with his 2 children. The trustee holds legal title to the residence, whereas Mr. Woods and his children hold all equitable title to the residence. That's what I described earlier. As a result, Ms. Herman's claim against the trust is necessarily a dispute with Mr. Woods. The trust has filed a motion to dismiss the complaint with prejudice. To the extent that the court declines to dismiss Ms. Herman's complaint against the trust without prejudice, the court should compel arbitration and stay the proceedings. After this action was filed, Mr. Woods commenced an arbitration proceeding against Ms. Herman before the AAA. So Ms. Herman had the option to bring arbitration. She did not. Mr. Woods then says, I see your lawsuit. I'm going to file a motion to dismiss. By the way, let's get this out of the court. Let's arbitrate the dispute. Ms. Herman says, nope, bet. I'm going to double down and file a lawsuit trying to set aside the arbitration agreement. She really wants this thing to be in a court of law, which gives you even more indication of her possible motivations here. If we're talking about arbitration and resolution of a dispute, there are rules that set forth the guidelines for choosing an arbiter, and there are ways to make that remarkably fair. This quite literally is, it shows that she wants this public. She wants this public. Yeah. So the arbitration arises from the same set of facts and circumstances of Ms. Herman's claims in this action. It involves the same individuals who will be witnesses in the action, and it involves the same conduct that has been raised in this action regarding the removal or misappropriation of Ms. Herman's personal property. In his statement of claim to the AAA, Mr. Woods alleges that Ms. Herman signed the agreement whereby she agreed to confidential arbitration of all disputes between her and Mr. Woods. Mr. Woods alleges further that after he broke off the relationship with Ms. Herman insisted that she had the right, pursuant to the alleged oral tenancy agreement, to occupy the residence for an additional 5 years, that she was wrongfully prohibited from entering the residence, her belongings were wrongfully removed from the residence, and $40,000 in cash belonging to her was misappropriated. Additionally, the arbitration alleges that Ms. Herman initiated this action against the trust in violation of the arbitration provisions in the agreement. In the AAA arbitration proceeding, Mr. Woods seeks a determination by the arbitrator that the claims in the lawsuit are subject to arbitration. There is no oral tenancy agreement entitling Ms. Herman to occupy the residence, and Ms. Herman is not entitled to damages in connection with the removal of her personal belongings from the residence or the alleged misappropriation of $40,000 of cash belonging to her. In other words, Mr. Woods' claims in the arbitration completely and totally overlap with the claims in this case. So I'm not going to go through the law on this one because arbitration clauses are always litigated. The court favors arbitration, generally speaking, especially when the arbitration clauses are broad in scope. They like to kick the matter to arbitration because the parties agreed to arbitrate the dispute rather than involve the courts. I've made the comment before that when the court has the option to basically kick the matter away from them, they will. They don't like to resolve a lot of these disputes. This particular case, especially because of a lot of the personal nature here, if I'm a judge, I'm uncomfortable reading that initial complaint. So essentially, that's the rest of the story that was just not reported. Going back to that original article, let's go ahead and pull that up. So please stay the proceedings and let us proceed with arbitration. Going back to that original article, and then we'll jump out of here. Because like I said, I want to keep this to like an hour. I think it's good. Go back to the original article, share the screen. Why am I having difficulty finding it? Let's do the New York Post article because that was a good one. New York Post, Tiger Woods. I want to bring us back to the very beginning of this, where we will leave it for the evening. So back to the original article. Here we go. Essentially, get out of here. I don't want to see that window. Go away. Tiger Woods' ex-girlfriend has filed a lawsuit against the golf legend, asking him to be removed from her non-disclosure agreement, citing a law that allows such NDAs to be voided if there's proof of sexual assault or harassment. Apart from the one sentence in that one pleading, did you see anything else? Anything? Herman, 38, is seeking to legally nullify the NDA she was made to sign in August of 2017 when she first started dating. According to court papers obtained by the Post. So they had the papers. The Post is saying they had the actual pleadings. She claims the NDA shouldn't be enforced in part because of the Speak Out Act, which was put in place to protect sexual assault and harassment victims. You guys starting to see where the context really starts mattering? Really starts mattering here? Like how much of this article makes more sense now? But going back to kind of the motivations between the relative parties here, how much more clickable is the article without the context? So there are no specific allegations referenced in the court documents. And going back down to the end of the article, refs for Woods and Herman didn't immediately respond to the Post request for comment. Herman, a former restaurant manager, claims Woods is trying to enforce the NDA via his trust amidst so-called litigation. It wasn't immediately clear what legal action or filing is referring to and whether it's ongoing. Well, New York Post, you have your answer now. According to the complaint, Herman is also seeking clarification from the court on what she is legally allowed to disclose publicly about her near 6-year relationship with the golfing champ. How does that make you feel? What are your thoughts? Because I'll tell you, when I when I read that article, I wanted to pull it up because I wanted to see what was going on. Just didn't make sense. I pull up the actual pleadings, and when the pleadings are referencing another piece of litigation, you then go and pull that litigation up. And then all of a sudden, with the added pieces, it all makes sense. Relationship breaks down. She can't sue him because of their arbitration agreement. So she goes outside the arbitration agreement and sues the trust who owns the property because she can't sue him because it's an arbitration. He files the motion to dismiss the lawsuit, the $30 million lawsuit, which, I mean, I get it. You're angry. $30 million. Didn't his ex-wife got $100 million? That was like the largest divorce settlement at the time in 2010. So rather than try to resolve the matter through arbitration, she brings a lawsuit for wrongful eviction. The trust responds and says, nah, dismiss, and then says, we're going to compel arbitration. They file that motion to compel arbitration, and she says, nope, not going to agree to that. Nope. Let me out of the arbitration agreement because of reasons. Doesn't give any specific language as to why. That's the other part that kind of just seems inherently misleading. You're telling me that wanting that adjudicated in a public court and going through all of those legal loopholes to have this dispute adjudicated in a public court, and you're not going to put one allegation in there? I'm not pretending that there might not be something there. I 100% agree. Not all women report stuff. I 100% agree. That said, you can very easily say that there were such actions of abuse that warrant the explanation. And to be honest, the way that Speak Out Act is going to require that to be argued, to the extent that she wants that NDA kicked, she's going to have to provide the justifiable basis for doing that. It's not just that there's the possibility of this maybe coming out. It's that there actually has to be a reason for the court to throw out that provision of the NDA. And she's going to have to demonstrate that at a hearing. I'm not going to read into the facts of this relationship. Honestly, the frustration I was having more so was with the reporting on it. Their relationship is their relationship. Y'all know how I feel about that. I practice family law. There are two sides to every single story, and I will listen to both sides if I have to, or if it's presented. I don't think that a court is a proper forum for a lot of the adjudication of this stuff, depending on the actual things that are being discussed here. But at the very least, when you have every major publication going out there and posting these salacious headlines, they better have something to back it up. And the other thing this does to Ms. Herman, whether she leaked this to the TMZ or whether TMZ found it of their own volition, I don't know, and I'm not going to speculate down that road. But let's say, hypothetically speaking, if that was leaked to TMZ, again, I'm not saying it was. If it was, then what she has done is cast the mirror right back down on herself to now explain to the public and others what she meant by that. And what's funny is she's not really going to be able to hide very much behind the NDA because, as she's already stated, certain provisions or certain things that actually amount to sexual abuse and harassment are outside the scope of that NDA. So I don't know I don't know. Right now, we don't have a hearing date on the motion to compel arbitration. So we'll see what comes of that. The NDA, that lawsuit was filed on the 6th. It hasn't even been served yet. So we're still waiting on service for that. I imagine we'll see responsive pleading within the next few days. But in either event, everyone that's going out there and saying that Tiger Woods has been alleged to have committed additional acts of abuse, they're lying. They're 100% lying, because nothing in those pleadings tells you that. Nothing. So that was kind of the point. People are going to line up to bash Tiger Woods, and some of them have that opinion. Me, personally, I think the guy's a great golfer. I have no idea. I like watching him play golf with his son. It's fantastic. It's heartwarming. But again, I don't know what people are like behind closed doors. So I'm going to try and respect the privacy that they have set up. We will see where the case goes and where the litigation goes. So let's see if I can catch a few questions and we'll wrap up here. This is, thank you very much for the super chat, Stephanie Coker. What is a special warranty deed? Thank you for the question. Special warranty deed. So when deed transfers property, the deed can be, there are certain things that are promises in that transaction. First and foremost, for example, in a general warranty, one of the warranties that are made in a general warranty deed is that you own title to the property. The famous case is the attempted transfer, the attempted sale of the Brooklyn Bridge, right? If I walk up and sign a document that says, I hereby deed you the Brooklyn Bridge, well, I don't own the Brooklyn Bridge to give you, so that deed fails, as it just fails. It doesn't transfer what it purports to transfer. Each one of these individual promises that are assumed within some of these deeds are warranties. A special warranty deed is a guarantee or a promise that's a very specific circumstance. For example, it could be that I own the property free and clear of any other claim or cause of action or a lien against the property, or that I hereby warrant to you that there is one lien against the property that I know of, and I shift that burden to you to determine what other liens might be against the property. But that's a special warranty deed. Elizabeth Webster, thank you very much for the super sticker. Let me see if I can catch some of these questions. Sarah, but abuse should lead to criminal charges, shouldn't it? How is that connected to those 30 million she wants to get kicked out of the house? Aren't those two different things? They are. And that's part of the reason this just doesn't feel right. This feels weird, because if there were actions of abuse, those are criminal in nature, and criminal reports are just period. The end of story. You can file those, and you should file those if you have the circumstances arise that would give rise to a criminal complaint. So it's not connected to 30 million. They're different things. How does one get into a relationship knowing it will last 11 years? That's what she is saying, claiming she has 5 years left. Yeah, that was weird to me. That was very, very weird. Because that first statement of 11 years. So how does that play out logically? I'm going to date you, but our dating life and your right to live here will expire in 11 years. Well, that doesn't sound right. I mean, at least say it's like in perpetuity, but they can't. They have to say a specific defined term. If they don't say a specific defined term, then it's a lease of indefinite duration, which would essentially, I think, necessitate a written agreement. So yeah, and it would violate the rules against perpetuities. So yeah. Let me see if there's any other questions. Scrolling through, make sure we've got all those wrapped up. Will the court filings be exempt from the NDA? They are. She's allowed to file. Yep. She's protected with absolute immunity in filing those pleadings. So that's the other part. She can't claim that she's not allowed to, because she can put it in pleadings to assert her rights. Apple Silver, Rob, would a prenup have any impact on damages? Prenups are very fact specific. Essentially, yes, it can impact what you're allowed to claim out of the relationship. This is not a prenuptial agreement. This is just a contract that binds the parties in discussing their affairs. So it's a little bit different to view that. Nanner, that was I answered that question earlier. Could it be that nothing was in the filings because she's under the NDA? Nope. And the legal filings are exempt from that process. So you're not subject to being to having a claim of violation of the non-disclosure agreement by filing a pleading that seeks to adjudicate your rights. So, all right. Looks like we caught just about everything. So sorry for the late notice, guys. Oh, thank you. Sarah Bellum, thank you very much. Thank you, Rob. It turns out to be frivolous. What, if any, will her punishment be? What's with the 40K? Also, thank you for my Runkle membership. Well, you're welcome. The second question, what's with the 40K? I have no clue. I told you they reference it on both sides. $40,000 in cash. What's with the $40,000? I don't understand the $40,000. And like all these personal belongings, oh yeah, and $40,000 in cash. What? Is the claim that maybe she like pulled that out of a bank account and that was subject to dispute, and like someone saying that she stole it? Is the claim that, she had it socked away? I don't understand the 40,000. If it turns out to be frivolous, what will her punishment be? I don't know. There will be punishment. It's one of those things where Tiger Woods might seek to have attorney's fees. I think the only remedy he wants right now, I can almost guarantee it just based on how his PR team works and has worked in the past. The only remedy he wants is get this out of the public light. This is a person who's very, very tired of having his personal shit like just brought up in public all the time. So I guarantee you he's not going to seek anything against her unless she goes below the belt on some of these allegations. We'll see though. I'll be really curious. Catching up question. See if I've got that. What has happened to that woman? Don't want to take care of themselves. I'm a woman. That women don't want to take care of themselves. I don't know. So, Catherine A. Rogers, this is weird. They were not married. Did she have a contract? Yes, non-disclosure agreement that was entered into. A lot of celebrities will do it when they enter into relationships because relationships bring the individual very privy to very private and confidential information. For example, if Tiger Woods is talking about, hypothetically speaking, a circumstance that are involved, his father and his upbringing. When they break up, of course, she's going to want to go and tell everybody. And just because he tells them in a relationship doesn't mean that everyone in the world gets to know, right? When you share secrets about your family life or about how you were raised or about golf tips or whatever the heck you share secrets about, when you're a celebrity and you're quite private, people have a desire for that information. So it's completely normal for these celebrities to say, look, if we break up, the stuff I told you about my past, you can't go out and write a tell-all book. It's honestly, it's a wise move. She couldn't find a bank to put the alleged 40K. I don't know. I got no clue. So, can't even respect him as an athlete because frankly, I don't hold golf in very high esteem at all. I'm sorry for that. The sport itself aside, it's a huge waste of resources stemming from the 15th, 17th circa elitism. Okay. That's fine. You can have that opinion. I'm not speaking about him as a person. I'm just talking about the reporting on it. Pretty unfair for both of them and for just you as a viewer of public media. So I hate that I'm thinking this, but was the money the top dresser? It could. Look, your speculation is as good as mine, period. Lauren L., thank you. What does the SA exemption have to do with the tenancy suit? Also, who the heck just casually leaves $40,000 leaving it laying around in cash? I don't know. I also don't have Tiger Woods' money. I don't have that money. That man has so much money. It is absurd. Look at the property. You saw the property. What does the SA exemption have to do with the tenancy suit? The tenancy suit was essentially, you owe me money. That's what that was. I'm going to get in court. You owe me money. Pay me this money, make it go away. He obviously offered an amount that was not satisfactory to her. This is me inferring from the pleadings and how they went. He offered an amount that was not satisfactory to her. And she said, or rather, then he responded to that tenancy suit, which was give me money and I'll go away. He responded, said, kick the suit out. Let's talk about this in arbitration. And she doubled down and said, I need this NDA thrown out because based on the motion to compel arbitration and the existence of the arbitration agreement, based on that, I acknowledge that this is a private dispute and essentially I know I'm going to be forced to arbitrate this. So I don't want to be forced to arbitrate this. I want a court to hear about all of our relationships and hear about the money he has and give me an award in the tenancy action. But I need a court to hear that. I can't trust an arbitrator to reach that decision. So how do I make the arbitration agreement go away? Well, I look at all the formalities required. I look at how an arbitration agreement can be illegal and I try to get it set aside. That's what that is. It's a tactic to get it set aside. And make it unenforceable. But thank you. Kristen McLaren, thank you. McClellan, thank you. She wants ex-wife privilege and mad she only got ex-girlfriend privilege. It sounds like Tiger learned his lesson and avoid paying out the $100 million again. Man, his dating life is wild. I think was it Lindsey Vaughn, other people, Rachel Ucatel, yeah. But no prenup, no agreement. May the Faith, thank you for the membership. Barney Cat, thank you. Generally, are you pro prenup for the average type couple? It really depends. It very much depends on the circumstances. I will say the longer you have lived your life, and the more complicated your circumstances are, for example, children from previous relationships, assets that you brought into the marriage. If you are a business owner, then you would want to talk to an attorney about a prenup. The old law school adage was everyone needs a prenup, but I take it from a more practical approach. I know that prenups are things that dissuade people from getting married, and prenups are things that are sometimes not technically necessary depending on your life circumstances. But let me see if we got anything else. Ladybug, did you know that golf stands for gentlemen only, ladies forbidden? Old urban myth. Yes, I do recognize that was golf, and it's a funny joke that is often said. I've also known several ladies that play golf in a manner that could kick a lot of guys' butts. Susan Feria, thank you very much. Okay. That wraps us up. We're going to keep this short. Look at that. Hour and 15 minutes. We can do short streams. So we have new context to the Tiger Woods lawsuit. Now you guys are updated. And now you can look at everyone who else is reporting all of this different stuff about, oh my gosh, you see the news about Tiger Woods. And you're now informed. You can go and tell them, by the way, did you know this? That's kind of my goal. I love being able to pass that information along because I honestly think that the discussions that you guys have outside of these settings are great. And I really don't trust a lot of the mainstream media these days. So that said, I hope you guys have a wonderful, wonderful Wednesday evening. Enjoy the rest of your week. And I will hopefully catch you on Friday for Friday Night Frenzy. Enjoy. Thank you guys for tuning in. And I will catch you next time.